Michael Popok, Legal AF. A Colorado judge was ever so close to declaring that Donald Trump could not be placed on the ballot for the presidency in Colorado because she found, as a matter of law, that Donald Trump engaged in insurrection and rebellion against the Constitution. That sounds exactly what's barred by the 14th Amendment and Section 3. But then it took a twist, and Ben Meiselas and me debated what we just observed with that Colorado judge and her 102-page order. Take a listen.
She didn't want the smoke. She didn't want the fire. She knew what the facts were that were presented, and she made the finding that he was an insurrectionist. But she, I think, was fearful of making the right order, or didn't want to be the first one to make the order, fearful of MAGA, whatever it is. She was psyched out because it just simply doesn't make sense. Let me just show you Article 2, Executive Branch of the United States Constitution. If you look at Clause 1, the president's role, it says the executive power shall be vested in a president of the United States. He shall hold his office during the term of 4 years, and together with the vice president chosen for the same term, be elected as follows. Then Article 2, Clause 8, the presidential oath of office says, before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States, Article 2, Section 1, Clause 8. And then if we go to the 14th Amendment, Section 3, the relevant provision for the constitutional disqualification, it says, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against him, the same, or given aid or comfort to the enemies thereof. But Congress may vote by 2/3 of each house to remove such disability. That's Amendment, the 14th Amendment, Section 3. And so here the Colorado judge said, well, if you look in descending order, it mentions senators, it mentions representatives, it mentions electors, it mentions members of state legislatures, it mentions executive or judicial officers of any state. So she says, if you look at statutory construction and you see a list like that, and it starts with senator or representative and descends with executive or judicial officer of any state, and you don't include president or vice president in there. And then she also says that previous drafts of the United States Constitution of this amendment included portion, had an initial draft when one of the people were drafting it that actually started off with president or vice president. Then it said senator, elector. The fact that that was removed and omitted, she says that shows that it does not apply to the presidency, and that the oath taken by the presidency is a different oath than what is invoked by this provision, which I don't know. I think that's actually torturing the statutory construction here, because it says, or as an officer of the United States, which to me is a catch-all. What the judge says is that it's not a catch-all to say officer of the United States, but not to use the direct words president or vice president, but simply subsume president or vice president under officer like any other ordinary officer. If you make a list in descending order, would not make sense that that's what was there, and that if the drafters of this provision wanted it to apply to the presidency and vice presidency, they would have just simply said it as they had in an initial draft.
Go ahead. Sorry.
I just want that's what she says, and then she makes the finding: Trump's an insurrectionist. He engaged in insurrection, and she rejects his both sidism, where he goes. Lots of politicians use martial language, like "let's go after him" or "let's fight like hell," and she goes, that ignores everything that he actually did that day and the lead up to it. I find he's an insurrectionist, but and then in the remaining 8 to 10 paragraphs of the ruling, out of nowhere, it's a 101-page ruling. So you're reading this thing, and it goes through how Donald Trump's witnesses are incredible, how the petitioner who brought the case, their witnesses were credible. And you're thinking, okay, he's about to get disqualified. And then you read those last paragraphs, and based on that interpretation, the way I described it, she goes, well, actually, it doesn't apply to him.
All right, she's wrong. I did a hot take on this, and let me tell you why I hate to say it because we liked her up until now. I still like her. I just think she got the analysis wrong, and maybe for the reason that you pointed out, where there's a kind of a subliminal fear here of Donald Trump and his followers. But what sounds like what she needed, which unfortunately was not presented in the record, was an expert on the Reconstruction period in American history, lasting 1866 to 1877, and what Lincoln and his successor was trying to do to put the Union back together again. This was not the only loyalty test that was required of people to come back to the Union. There were a number of laws that were passed, of which the 14th Amendment being ratified, Section 3 was one of them, to make sure that before they let them back into the Union's house, at the front door, you took a loyalty test and an oath. And if you couldn't pass that test, you weren't going to be able to serve in office again. That's one. The second thing is Lincoln and the successors to Lincoln were worried about Robert E. Lee and his followers, just like we're worried about Donald Trump and his followers today, and pissing them off, and to try to also at the same time bring brother and sister and brother back together again after a civil war. We like to use that term, civil. There's going to be a civil war. If this doesn't happen to Trump, there's going to be a civil war. We had a civil war, and it went on for a number of years, and hundreds of thousands of people died. Go to Gettysburg, go to Appomattox if you don't believe me. I've been to those places on school tours. Okay, we had a real war where brother against brother and fought against each other to the death over our country, and then we had to reconstruct it and put it back together again. So the fact that the presidency and the vice presidency were not mentioned by name is more, I believe, based on history, have to do with not alienating people they were trying to get back into the Union than because they wanted to have or allow our founding fathers or the people during this period a rebellious, traitorous president to be on the ballot, or to give that a permission. And that's why, as you pointed out, right, Ben, there's this catch-all. Now, how do I know that he's a federal officer holding the office of the presidency? Yes, it's all the times you mentioned office in the oath, but also he just recently took the position, which the judge completely ignored, in a federal removal petition that he brought in the E. Jean Carroll case, the defamation and rape case, where he tried to get it away from federal Judge Kaplan and bring it over to no, I'm sorry. Let me try it again. He tried to get his Stormy Daniels case. Sorry, try it again. Restart, Popok. Stormy Daniels' hush money cover-up case away from Judge Merchan and bring it over to a new federal judge. And in order to do so, he had to take the position, Trump, that he was a federal officer entitled to federal officer removal. So how do you then say he's a federal officer, which he's already acknowledged? He has to take the oath. Yes, his oath is the last line firewall of defense of the Constitution and our constitutional republic, because he's the commander in chief. So it would be weird if he said support the Constitution the way the Congress people say it, or other officers say it, or cabinet members say it. He is the commander, or she is the commander in chief. So she has to preserve, protect, and defend the Constitution because they got the finger on the button of the military. Right? That's why they get that, but that doesn't mean that all those things, preserve, protect, defend, don't equal support. And so the judge got all wrapped up with, well, let's look at the oath difference. This one says support. This one says defend, preserve, and protect. I'm like, they're exactly the same thing. The only reason the presidency has this other duty is because they're the commander in chief, right? We expect the president to protect the Constitution. That's something that always gets left out of the 14th Amendment analysis, not on legal AF, but in general. It's not just that he's a insurrectionist and engaged in insurrection or rebellion. It's insurrection and rebellion against the Constitution. That's what the judge gets right in her analysis, that the word same means the Constitution. So we're looking at the relationship between the federal officer and the Constitution. All have to support it. One has to defend, preserve, and protect it, and that's the commander in chief. But that doesn't mean, oh, that's the out. Here we go. Because they didn't use, they used a different oath version, and there was this earlier draft because they didn't want to piss off Robert E. Lee's followers that had his name up there at the top, and rather than the catch-all, oh, that's it. Sorry, you're not going to use the 14th Amendment to disqualify him from the ballot. Now you've got one issue left on appeal. This group that brought the case is going to bring it up on appeal to the Colorado Supreme Court, ultimately to the U.S. Supreme Court, on the issue of whether the 14th Amendment and this whole issue about the drafts of it and the legislative intent and the oath that were taken about each applies to a rebellious insurrectionist president. Yes, no, thumb up or thumb down. And that, no, it's going to go on an expedited appeal because this issue has to be decided before the ballots are printed in November. And while we're watching, and I'll leave it on this, Ben, all we're watching are various courts, whether it's Michigan, Minnesota, Colorado, at the Supreme Court level, at the original jurisdiction of a court level, trying to struggle with how to apply something that the framers left us, but without instructions or an instruction manual on how to implement it. I heard one of the legal commentators recently on one of the news shows say, it just shows that we don't understand procedure and it's really hard. Okay, that may be true. And it may be the first time we've had a rebellious insurrectionist president that we've had to go after under the Constitution that is our governing document. But that means that we now have to have the gravitas. I'm talking to the judges here. The gravitas, the steeliness, the balls, the steel to create the procedure, because it's supposed to be, and this is where the judge got it right and wrong. She said in her 101 pages, constitutional provisions and amendments need to be broadly and liberally interpreted. And then she did the exact opposite. She made it narrow, looking for exit ramps and outs. Some judge is going to have to stand up here like she originally did and say, I interpret constitutional provisions. And just because there's not because the Constitution is not a statute book that gives you chapter and verse in 500 pages of federal regulation, like it's in the CFR, the Code of Federal Regulation, exactly how to do this. You have to do it by court precedent and common law. And these judges and Supreme Court judges that want to punt and say, oh, it's a political question, goes back to the Congress. We don't want to deal with it. And this judge, I can deal with it, but I don't want to deal with it. So I'm going to misinterpret the last provision in there and punt it off to my higher bosses at the Supreme Court level. Somebody's got to stand up once and for all and say, I need to implement and execute the language of our U.S. Constitution, that sacred language, and do it at the most critical time in our history with a former president that I have found to be rebellious and insurrectionist. I have to do it. And we can't just bang our head and go, oh, it's so hard, so complicated. What do we do? They didn't tell us what to do with it. Ridiculous. And so I want to have, let's see what Colorado Supreme Court does. You and I will figure out the makeup of that court and how that may impact the decision-making. And then ultimately it's going to go to the right-wing MAGA Supreme Court and the 6-3 majority, which to date has not sided with Donald Trump on many or all issues that are important to him. And we'll have to see what they do here. We know Alito and Thomas will instantly find a way to say that it doesn't apply. I'll write their dissent right now. The question is, can John Roberts count to 5 and get 5 votes to find that it applies? Not just for Trump. Yes, I care about Trump, but let's be frank. One day he's going to be dead. I mean, from natural causes. And we'll have another Trump. And then somebody who's going to try to use his playbook and test the guardrails of democracy and our justice system even more than this guy. And that's the case law and the body of precedent that I care about, that our audience cares about, that you care about, Ben, that we're watching the development. All of the cases that are going to have the Trump name on it moving forward, state and federal, Supreme Courts all over this land, are going to be important to our democracy moving forward to avoid and to stop the toppling, accidental or otherwise, of our democracy by the next Trump. That's what I worry. I worry about this guy. I worry about the next guy or woman. Well, there's an example of the nitty-gritty at the intersection of law, politics, and justice legal analysis that we do twice a week, Wednesdays and Saturdays at 8 p.m. Eastern Time, only on the MeidasTouch Network, on a show we call Legal AF, and the title is exactly what you think it is. So if you like that kind of content, come join us for the full podcast. If you know about us already, welcome back. Appreciate you. If you are seeing us for the first time, come join the ride. And if you already know all about us, take that clip, send it off to friends, family, and followers, and get them to join us. Free subscribe to the MeidasTouch Network on YouTube. Help them get to 2 million free subscribers. It's an independent media company, no outside investors, and so we need your help. And the bigger they get, the more your voice is heard. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.